We're on a record in cause number 311900, the state of Texas versus Nicholas James Randell. Is that your full name? Okay, how you doing, Mr. Randell? I'm doing fine, Mr. Randell. You are represented by attorney Jerry Gilthorpe. Mr. Gilthorpe is appearing via Zoom. Mr. Gilthorpe,
Yes, Judge.
how are you doing?
Doing well, Judge.
Okay, you could turn your video on. Mr. Gilthorpe, Mr. Randell case is on the court's announcement docket. Do you have an announcement that you would like to make for Mr. Randell?
Yes, Judge. We're still waiting on discovery.
Okay, how much time do you need?
Um, I mean, a regular reset would be sufficient. I believe we requested our discovery earlier this month. The state's usually pretty good about getting it to us, and once we have it, we'll review it and we'll get ready.
Okay, give me a date. Okay, it's gonna be reset to April 23rd. Now, Mr. Randell, before you leave, you can get a copy of your reset. You're gonna stand over there by the court coordinator. Once you get your copy of your reset, you'll be free to go, and you have a blessed day. Okay. Yes, you can go over there right now. We're on the record in cause number 320090. The case is filed the state of Texas versus Luis Francisco De Leon Sanchez. And Mr. De Leon Sanchez has another case, cause number 323156. Your full name is Luis Francisco De Leon Sanchez. How you doing, Mr. Sanchez? Doing all right? That's good. Mr. Gilthorpe is your attorney, Mr. Gilthorpe. Mr. Sanchez case is set on the court's revoked probation docket. And Ms. Samuel is here from the probation office, and I think he has one case that's a motion to revoke probation. Is that correct?
Yes, Judge.
And that case is cause number 320090. In reference to the motion to revoke probation case, Ms. Barlow, what's the recommendation from the probation office? Mr. Gilthorpe, did you hear what Ms. Barlow stated?
I did not, Your Honor.
Okay, she said that the probation department's recommendation is to proceed with a revocation. And so what is your announcement in reference to that statement?
Well, Judge, my understanding is that his violations is that he has not paid. He's behind on his money, and he hasn't done his community service hours or done his class. But that he was a regular reporter, and I think he had a misunderstanding. I think he could complete his probation. I think he could do that. But I would ask that the court hold it in abeyance until we finish this other case. If he's convicted of this other case, I think it makes it a real easy decision for the court. It's a simple revocation.
Do this, so the other case that you're referring to is cause number 328156?
But that's correct, Judge. It's an eluding case, and we would request a trial on that one.
Okay, now, so you're gonna be requesting a trial on that case. Now, state, Ms. Ramos or Ms. Musgrove, who's handling this case?
This is my case, Your Honor.
What is the state's position?
Your Honor, I just realized that the eluding is not alleged in the MTRP case. I will be reviewing to see if the state wants to amend the MTRP to include the eluding in that case as well. But, and then if he wants a trial on the eluding, I have no opposition to a trial.
Okay, now, how much time do you need, Mr. Gilthorpe? Now, you want to reset your second case for trial, is that correct?
That's correct, Judge.
Okay, could you give us a trial date? Okay, the trial date is June 14th of 2021. Let me ask you this, Mr. Gilthorpe, do you want both cases set on the same day?
That's fine, Judge, because we'll try that case, and if we're successful, then we'll be back to our negotiations, or I think he can be caught up on his money and have everything done through probation by then. If we're not successful on that case, then I think it's a real easy decision for the court, and I would agree to a revocation.
Okay, so we're gonna reset both cases to June 16th of 2021.
That works. Thank you, Judge.
Okay, you're welcome. Okay, and we'll send you your reset in the mail, Mr. Gilthorpe.
Okay.
Oh, you gonna fax it? Okay, it's gonna be faxed to you. And Mr. Sanchez, you can stand over here in front of the court coordinator. She's gonna give you your reset. Once you get your reset, you'll be free to go. Okay? All right, you're welcome. All right, and you have a blessed day, Mr. Gilthorpe, and you have a blessed day as well, Mr. Sanchez.
Same to you, Judge.
Okay. Okay, we have another matter. We're on the record in cause number 326278. I have a motion here. Well, the case is filed State of Texas versus Diane Gonsolin Hastings. And Ms. Hastings is appearing via Zoom. Ms. Hastings, you can take your mic off of mute.
Got it.
How you doing, Ms.?
Good morning.
Good morning. How are you doing?
Good. How are you?
I'm doing fine. Thanks for asking. And Ms. Hastings, you're here represented by your attorney, Mr. James Macon. Mr. Macon is also appearing via Zoom. Mr. Macon, how are you doing?
I'm doing fine, Your Honor.
That's good. Now, Mr. Macon, I have your motion here to remove the interlock device from the vehicle. And if I'm reading your motion correctly, it states that the movement files this motion to remove the interlock from the vehicle, and in support of this motion shows movement will show that the interlock was a condition of her bond. Could you give me that bond condition? The cause number is 326278. And you said the bond, she has been released?
She pled to the charge on February 12th of this year, Your Honor.
Okay, let me.
And as part of the plea bargain, there was no interlock provision.
Do you have that judgment in that cause?
And I've had it a year.
Okay.
I've had it a year already.
Yeah.
Okay, that's fine. Let me, just
Yes,
trying to
sir. It was part of the version.
Okay. The plea, no, I got the, yeah, it didn't have an interlock in here. Okay. Okay, the court is looking at the standard bond conditions that was filed on or about, well, on July 17th of 2020. And in this bond condition, condition number 4, the defendant whose information charges any offense listed under section 49.04 or 49 through 4906 of Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes it practical the operation of the vehicle if ethyl alcohol is detected on the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before the date scheduled for the appearance. Ms. Musgrove, put your mic on mute. Ms. Musgrove, put your mic on mute.
Yes, Your Honor.
Okay. and Mr. Macon. And so Ms. Hastings have a interlock device on her vehicle because as a result of the bond conditions. Is that correct?
That's correct, Your Honor.
And also, I
In
see,
fact, she had shortly for a time period was in the diversion program, and that was a condition then. But because of her moving to Austin, she got out of the diversion program, which moved us forward to entering this plea.
okay. Now I see that this case, I'm looking at a judgment that is dated February 12th of 2021. And so the case was disposed of on that day. And Ms. Hastings was given probation in that case. And the interlock was not a condition of a probation. Am I correct?
You're correct, Your Honor.
Okay, now pursuant to Article 17.09 of the Texas Code of Criminal Procedure, it states in Section 1, where a defendant in the course of a criminal action gives bail before any court or person authorized by law to make same for his personal appearance before a court or magistrate to answer a charge against him, the said bond shall be valid and binding upon the defendant and his sureties, if any, thereon for the defendant's personal appearance before the court or magistrate designated therein, as well as before any other court to which same may be transferred, and for any and all subsequent proceedings had relative to the charge. And such bond shall be conditioned except as herein provided. And the question that most people have is the term and for and all subsequent proceedings. And now pursuant to Trammell v. State, 29 Southwest 2nd, 528, that's the Texas Criminal Court of Appeals, 1975. The primary purpose of bond is to ensure the defendant's appearance at trial. It is not intended to ensure compliance with the conditions of probation. Therefore, based on the statute and based on the case law, the court is going to order that the interlock be removed from Ms. Hastings' car. State, you have any objections?
Yes, sir.
Uh,
No objection, Your Honor.
Okay, so no objections. The court is going to sign the order releasing the interlock from Ms. Hastings' car. And Mr. Macon, this will be, once we sign it, it'll be e-file, so you should get a copy of it.
Thank you, Your Honor.
Okay.
Thank you, sir.
Okay, you're welcome. Mr. Macon, do you have anything else?
I have nothing further, Your Honor. Thank you very much.
Okay, you may be released or you may be excused and have a blessed day. And Ms. Hastings, you may be excused as well and you have a blessed day.
Thank you, sir. You as well. Thanks.